So thank you, Amy Kong, for introducing AREAA to all of us and the audience and participants. Vancouver chapter, we have the screenshot. We have our president, Seti Minachi, our founder of our Vancouver chapter, Tina Mak, Tiffany Vu, Lisa Ng, Jordan Chan, Dennis Fan, and myself. And look at the wonderful color of Asians that we have on our board. Many of you out there who are not members, we encourage you to come join and check us out. We had a lot of different events during this year, even during the midst of a pandemic. During that period of time, we had a lot of interesting Zoom seminars, one on tax issues, one on real estate during the COVID times. We had and a multicultural real estate agent experience and a session that was really done, I think, in just before the pandemic too. Anyways, we have lots of stuff to offer. Now, feel free. And what I have at the next screen is my contact, but at the very top, you'll see the email of our president, Seti. So any information you want to join, you want to come in, you want to find out more about us and what the AREAA does and what we can do for you, make sure we contact and reach us out. Of course, when you contact SETI, you can also check us out on the website, the AREAA website as well. Okay, and so today's topic, we're talking about rent collection and evictions in the midst of the pandemic. So a little bit about myself before we go to that point. I've been practicing real estate for 23 years. All kinds of real estate buying, selling transactions, but also litigation. In the last 6 months, especially, been very challenging when it comes to residential and commercial tenancies on behalf of mainly landlords, but also on behalf of tenants as well during this period of time. And so this topic has come up because there's a lot of people who are affected by it. As realtors out there, you're affected because you have clients who are buying a pre-sale, a home with tenants. Maybe you're acting for a seller with tenants. Maybe your buyer wants to buy a home that has to be vacant, that are currently tenanted. Maybe you're a property management company that have a lot of tenants. You are acting on behalf of landlords and with issues about tenants who are not paying their rent or paying late. So all these issues arise. The litigation before the Residential Tenancy Board is a mystery to many people. It's not necessary to have a lawyer, but there are a lot of places and things to think about, places to go, things to do, and things to read up about in order to be effective in terms of representing either yourself or your clients when it comes to the board. And you don't have to be a lawyer to represent your buyer tenants or your selling tenants, clients. You can be an advocate, you can be appointed as a spokesperson, but most important, you have clients, buyers, sellers, managers, landlords that you need to give advice on, and in terms of telling them where to go or what to do and what steps to take. Okay, so this is myself here. You can contact me here, and this is my number as well. And I will start with their presentation. Before I move to the next screen, what I wanted is, in knowledge is power. You guys know more, the more you're able to effectively help your clients and your customers or yourself. One of the important things to know is where to find what you need to look for in order to help and educate yourself. I want to point this out because where do you find things? You start with the law, which is the Residential Tenancy Act. Then the regulations, which is meant to determine how the act itself is implemented. Then there's the rules of procedure. If you ever type or Google us in or send us a request for a PowerPoint presentation with web links, you can do it. You can also just Google this, Residential Tenancy Board / rules of procedure, the guidelines, past decisions. These are all very important things to find information. Rules of procedures is what the board members and are used to guide their decisions and how to interpret the terms and the law that is found inside the act and the regulations. And the guidelines as well, like the procedures is more technical, like timing and how to serve documents and things and what the evidence should look like. The guidelines is how to make those decisions based on those laws. And then there's always past decisions. You go onto the website itself and you type in a couple of search words, perhaps tenancy, eviction, COVID, and see what pops up in terms of what it is. Unfortunately, the Residential Tenancy Board past decision cases that function, they won't let you in terms of narrow down certain things and perhaps filter. You just get a lot of cases, and there's nothing to substitute reading all the cases to figure out which one is going to be relevant to you. So these are the main sources. If you want to self-education, education is so important. So look it up and check it out. If you ever have an issue, what does the act say? What does the regulation say? What the procedures say? What are the guidelines say? And what do the past decisions say about this particular issue? I remember in the middle of because Residential Tenancy Board hearings continued during the pandemic, it wasn't because most of the cases are done online or by telephone. So, the decision still kept on happening. The court decisions still kept on being decided, and people still go to court because it's all online and on telephone. So it was interesting time to be making presentations by video or by telephone during this period of time. Now, next thing is, what are the issues that has come up? And these failure to pay rent, landlords whose tenants have lost their jobs and lost their businesses, and the business had to be shut down, they can't pay rent, and those who are able to apply for some benefits, which are great. Owner use and occupation, so many tenants cannot be evicted during that period of time, even with the legal notice given. So the question is how to have possession of the house or the property. Vacant possession, this happens most real estate. The buyer wants to buy a house that's vacant for their buyers to move in. The sellers want to do the same. They sign a contract, but then during this period of time, the tenants cannot be moved out, even if the legal notice was given. And then even if you have an order of possession gotten and received at the Residential Tenancy Board, you can't enforce it. And so that was a huge issue as well. Next, other ones, frustration of contract came up a lot. The idea was, hey, do I have to pay rent because, I lost my job, and nobody could have thought of that? Well, not really. So there's a whole lot of issues dealing with the law surrounding what does it mean to have a contract frustrated? Can parties back out? And the short answer to that, COVID was never a reason to back out, because it's meant to be more of a permanent nature, even though it sure seems permanent to us right now. I can't imagine the time it was in February when March, my birthday, when I last went out for dinner with my family. Anyways, it seems like a long time ago, but it's not frustration for contract purposes. Or repeatedly rent payments. Rent payments are repeatedly late. That's another issue. And then extenuating circumstances. What part of COVID and during the pandemic, what parts of it can be used as a reason to justify not complying with provisions that are required under the law, especially for landlords who argue extenuating circumstances. So these are all issues that come up. And every single month, I had many cases that all touch on every single one of these. So I had to work them out, all through them. So, but what is I just mentioned, the Residential Tenancy Board procedure may be a mystery to many who doesn't or have not gone to the board. Just want to give you some ideas about what happens and what is the process. So it's by video or teleconference. People phone in with access codes. You have to provide proof that you served documents to the other party. You can hire process servers. During the pandemic, they allowed exemptions to email documents to each other so long as the other person can demonstrate they were able to receive and open documents sent by email. Evidence is very wide. It's different than the Supreme and Provincial Court. You can send almost anything in, and I've had letters, pictures, videos, anything that can be used, and even case law is considered evidence. You present it and forward it to the other side. Thing about many people don't know is that cross-examinations are allowed. So if you put yourself up as a witness, the other party can question you and ask questions. It could be a lawyer, could be a representative, could be the tenant or the landlord themselves. And who goes first? It's the applicants. Like normally the landlord will issue a notice of eviction. The tenants dispute it because the tenants are applying to dispute the eviction notice. They're the ones that normally go first and present their evidence. Unless the tenant is accusing the landlord of doing something that's not like an ulterior purpose to whatever it is that their reason you're using to have the notice of eviction to the tenant. So, for example, if the notice says you leave in a month because of cause, or leave in 2 months because the person, the landlord, wants to use the tenanted space, the tenant is saying that's just an excuse to get me out or something to that effect. So that's bad faith. And if it's a bad faith allegation, then the person assumed to be alleged to be acting in bad faith goes first. And then a decision comes, usually about a week, pretty quick. They're very quick, especially during this period of time. Decisions usually about a week, sometimes 2 after a hearing. Okay, so it's not a mystery. But now the next thing is very, very technical, but it's so important when it comes to the Residential Tenancy Board. How much time do you need to do certain things? And they're very sticky to this. They may be a bit lax in terms of evidence, but they're very, very strict on their timelines. You miss a day, you're half a day late, they don't care. You miss it, you don't file it, you don't get to use it. You miss it, whatever you want, you don't get it. So here's a quick recap. You can jot this down, take a picture, screenshot, because this is very important. If they don't pay rent, this is normally, okay, so this is, in a normal time frame, you want to send a notice of eviction to a tenant because they didn't pay rent. There's a 10-day notice period, no compensation needed. The idea that for cause, so if they were, if the tenant was, for example, causing a nuisance to neighbors, is violent and destroying property, then you can send a 1 month notice to have the tenant vacate the premises, and then there's no compensation. It's important about this compensation part because if you do, for most purposes, most people do a notice because the intention is for the landlord to occupy, or in the case of a buyer who is buying a property to move their family in to occupy for the buyer. So there's a 2 months notice requirement and then 1 month rent compensation. And then for renovations, you need a 4 months notice with a 1 month rent compensation. So this is very strict. And there's other technical things in terms of you have to have 10 whole months. You have, sorry, not 10 days, 10 whole days, 1 whole month, 2 months total. You can't do halfway during the month to have an eviction to take effect on the 1st of the 3rd month after. It doesn't work that way. It has to be whole months. Okay. So next thing I want to talk about is, if you are a landlord, you are a buyer who wants to have a property and then have issues dealing with the tenant. What are the steps involved if you have a tenant that for whatever circumstances they are in, don't, or despite the legal requirements qualifying, they don't leave. So you issue, these are the quick recap of the steps. You issue the notice of eviction for whatever purpose, the 1 month, the 10-day, the 2 months, the 4 months. You serve it. The tenants, if they dispute it, they apply, but they dispute it. And then if you go to court, and then you might get an order for possession. But if you are the landlord, you might want to apply for the court order of possession. If you send a notice, the tenant doesn't dispute, then you have to, as a landlord, apply to the court for an order of possession. So if you do appeal, if the tenants appeal, like, and make an application, you have to go to the hearing. Once you go to the hearing, and if you're successful in getting an order of possession, then you have to register that with the Supreme Court, and serve it first and register with the Supreme Court, and then hire the bailiffs to perform. And now this is under normal circumstances. We're in a different time, and there's a lot more rules and precautions that needs to be placed, and I'll be talking about that in a minute. But that's the quick recap of the steps. Now, one of the things that doesn't get talked a lot about is late payments. Where does that fall under the whole category of schemes? The category of where if a tenant is late many times during this period of time, it's not a non-payment of rent issue, which there is a ban on evictions for that purpose, but there are also that this is for cause. So when you have cause, that's a 10-day notice, and repeatedly late for rent, it's been an issue. So here, under the law, Section 47 of the Act talks about landlord may end a tenancy if the tenants are repeatedly paying rent late. But there are other special guidelines. When is late? Late doesn't. How many times do they have to be repeatedly late? to be considered of grounds in which you can evict a tenant for cause. Now, it has to be 3 times at least, and it doesn't have to be consecutive, but it does have to be in a way that it can't be considered a one-off. So if you're once late and then another time late a year later and then another time late 3 years later, it probably won't count as consecutive or repeated being late because there's too much time in between. So just be careful about that. Now, starting in July, of course, this month, sorry, a couple months ago, there was a ban on not only getting it, but enforcing orders of possession. But that stopped since July 2nd. They can be enforced for these particular causes, okay? So these kinds of reasons, use, cause, and extensive renovation, they allow landlords to apply to the courts for orders of possession, but as you see here, not rent, not when you're not paying rent, okay? Non-payment of rent is a whole different category. So here, you can't, since for that period of time frame from March to August, not too long ago, but there was not an ability to issue 10-day notices for evictions for non-payment of rent. And that was extended for 1 month to the end of September. So, and then even then, if there is a 10-day notice given, you know, nowadays you can't enforce it unless the tenant has not paid rent based on a new plan called the repayment plan that is served on a tenant. I'll talk about that in a minute. Well, actually, right now. So starting September, if the new laws that are regulations are now in effect, is that if the tenant did not pay rent from March, April, May, June, July, August, now you can't just, as a landlord, now that it's open for orders of possession to be granted, you still can't give a notice to the tenant to leave until they fail to pay a repayment plan that was initiated by the government to continue the protections afforded to tenants. So and there's some specific rules for this repayment plan, and this is brand new. So if you need to look for the rules, it's guideline 59, I believe. It could be 52 as well, but the latest guideline, if you look under residential tenancy guideline, repayment plan, and they'll give you actually it's a 10, 12-page document dealing with all the rules about repayment plans. Basically, in a snapshot, what those rules are, starting September 1st, 2020, landlords must first revise and devise and serve a repayment plan to the tenant and give 30 days for that to take effect and allow the tenant until next year in July 21st to pay off that plan. So if they had, for example, $2,000 a month they were late, or they did not pay, say for example in May, $2,000 a month they did not pay in July, $2,000 a month they did not pay in August, so they're overdue and they did not pay $6,000 of rent. What the landlord has to do starting now is to look at the time frame from starting, well, if they give them the notice in September, from that time until July 21st, 2021, divide that by the number of months into the amount owed so that they have to be equal installments to pay that amount that's owed back. And only if the tenant misses a payment on that prepayment plan installment, then the landlord can start a 10-day notice of eviction for the tenant not to have not paying the rent. So you still can't do that for anything that was not paid from before. You have to give them that equal installment plan until next year in July 21st, 2021 to pay off this outstanding rent. And that is like, who devises this plan? It's the landlord's responsibility. So if they even want to go to give a notice, they first have to give this plan, and then they have to have the tenant not pay on this repayment plan, and then they can start a 10-day notice only if the tenant do not repay the repayment plan on time. Okay. So anyways, these are all the new rules that allows for the protection of the tenants continue on, but it doesn't completely eliminate it. It's no longer a complete ban. And it's pretty tough still. Like imagine if you pay $2,000 a month rent, then you have to pay on top of the $2,000 a month rent going forward, on top of that, an equal installment of the amount that was due before. And it's still pretty tough. for a lot of tenants out there. But anyway, so there is some measured protection, but there's also not complete ban either. So it's some protection, but not complete. So another situation has come across with, it happened with a lot of my clients in the last little while, is the user occupancy as a reason for eviction. So if a buyer, for example, has a contract and wants to buy a house for their family to move into, but there's tenants in the home, what about those situations, and how has the courts in the last little while been dealing with that issue? I've had a situation where I had a buyer, my client was the seller, the client passed, the buyer passed away because of COVID. But then my client was all planning to sell this house to move back to another country, had 2 mortgages to pay off and a private loan, otherwise had to carry this loan, continue until the next buyer comes along. What are we gonna do? So the idea as a lawyer for the seller, what do you do in this situation? The buyer has a deposit. Who can act on behalf of a deceased person? And that required the fact that, do they have a will? Does the deceased buyer have an executor appointed? Do they have an administrator who can apply? And these are all different things. And if you are not familiar with the BC real estate contract section, paragraph 19, contract is binding on heirs and executors and assigns and assignees. Small little tiny print. If anyone sees the BC contract approved by the Real Estate Council, it's tiny, tiny, tiny print. It's binding on executors and heirs and estates of the person who passed away. Anyway, so we'll go from there. So I want to go to the next one. So this issue is not only if a buyer wants in, that maybe the landlord, the owner wants themselves to move in. It's not a buyer that wants to come in. So that's another issue as well. Okay. And the rules allow for this application to be the buyer or the landlords or the close family member of the buyer or the landlord. But there are some certain rules about what it means to be close family members. Not anybody. Anyone, I guess it's not everybody's muted, but you can put what your chat and what you think is, what does family member include that allows for occupation of the place here. And before you go on, here it is: a father, mother, child, landlord, or landlord spouse. It does not include brother or sister, or the landlord or the brother of another mother. Sorry. Anyways, family corporations is one of those complicated ones, which there are some exemptions to it, but it's pretty complicated. I won't do that here. I'll talk about that in depth now. But let's look at this way. 2 ways to end a tenancy for new or soon-to-be landlords for rental property. Normally what happens is when you're writing a contract, you have to make sure that there's a 2 months period of time, 2 whole months. So I would normally say 2 months and 2 days, upon which you can put in the contract for vacant possession to be given to the buyer. If there's more than one tenant as a landlord who then has to sell the property, you want to make sure that this notice is given to each of the tenants of the room, of the property. Another thing that a buyer can do is, instead of having it in the contract, waiting for 2 months before you complete and take vacant possession, is to buy the property and then turn around and give the 2 months notice to the tenants to leave. And quite often, and that situation happened during this pandemic period with a couple of my clients who thought they had a good deal, turn around, gave the notice, and all of a sudden the tenants wouldn't leave, and then they're stuck. So if anything, if you can get the vacant possession before you take over, that's the best route, because there's a lot of uncertainty if you take over a house with tenants and then with a plan to give a notice to the tenants to vacate, because you might encounter a lot of problems, and the problems that I can go through as well, because I'm going to go through some of those problems right now. 2 main issues: tenant does not want to move out despite a valid notice being given as part of a contract of purchase and sale, and then tenant disputes the notice on the basis of bad faith. Now this is very important, because you don't expect that part, yeah, but it happens. So here, tenant does not vacate. Issue 1. During the eviction moratorium, the seller would be in breach of the contract and liable for damages if they had agreed for a vacant possession and the tenant would leave. That had to happen. I had possession where then all of a sudden you have to think about, well, it's a breach of contract, not enough for fundamental breach, but it's enough for the buyers to sue the seller for not giving vacant possession. You can't meet one of those conditions. What are you going to do? You have to negotiate. Some buyers or sellers have talked about cases of frustration. Hey, look, I know I signed the contract for the tenants to leave, that it's not my fault that the BC government has a moratorium and I can't give it out to you, but it's not frustration contract. It doesn't allow for the contracting parties to leave as if the contract never occurred. It's not permanent enough to qualify. And it doesn't change the fundamental nature of the contract. He's still getting a house. If something happened to be qualified to be called frustration, then what you're going to get if you enforce the contract would have to be something substantially different than what you bargained for. So if you force the contract, you still have a house. You might have tenants in it, but you have a house. So it's not fundamentally different enough to be frustration. And then you have to sue for breach of contract if you were acting for a buyer. And then the question is how much? How much is it worth? You have tenants in the property, you didn't want it. How much are you going to ask the seller to compensate you for? You might have to wait. You might have to take them to court. You might have legal fees to go to residential tenancy board. You might have to rent out a place while waiting for the tenants to leave. All these things are potential things to think about when negotiating how much of a compensation should be given to a buyer on one hand to compensate for having a breach of contract. But then the other issue is even more problematic. When you issue the notice and they challenge the notice because, hey, that's not the real reason why the landlord wants me out, or that's not the real reason that the buyer wants the property for. And in this situation, there's a really important part that really is hard to prove, but sometimes it's so important to keep track of, is the good faith requirement when it comes to these notices of eviction. You give a 10-day notice of eviction because they don't pay rent, but they say that, well, that's not the real reason. The landlord's been trying to get me off the tenancy for the last 10 years. This is just another excuse to get me out with your tenant. We've always had these complaints about repairs and maintenance, and the tenant is up to, makes the landlord really fed up, and that's the reason why the landlord wants me out. So these are challenges based on the landlord's good faith effort to actually get the tenants out. Is it on the real reason that's given on the notice, the 2 months notice? Or they really want to use it for the family member, or is it just an excuse? Is it really they want to do renovations, or they just want to charge higher rent after they renovate? Is it that the reason? Okay. So then my next one, good faith requirement. Now, this is where you look on the regulations because they don't define good faith in the act. You need the guidelines and the regulations to figure this one out in old past cases to see what it means. So what you have here, good faith requirement. You need to have, if for example, if they're ending a tenancy to move in or family close member move in, the definition that's found in the guidelines, the landlord has an honest intention and no ulterior motive. This is key. I bolded this thing about no ulterior motive because if one of the reasons is right, but there's other ones, then it becomes a point of which one is really the primary reason. And the evidence from the cases that I've worked on and looked at is if there is any other reason, then that any other reason clouds the whole idea that the primary reason is, for example, for a family member to move in. So you practically, in one sense, if you want the tenant to leave because of a family member moving in, that better be the only reason, because they can challenge you as a tenant on that, because you do have another ulterior motive. And the guidelines say no ulterior motive. It doesn't say the main one or one of three or it's the top one of two. It's not. It says no. And then the landlord, though, then has to give extenuating circumstances as reasons to show why they don't have to be doing what they said they're going to do on their notice in the first place. Okay. So how to fight allegations of bad faith. I do this way because for the majority of the residential tenancy disputes that I've acted on behalf of during the last 6 months, have invariably all been landlords who then have been alleged to have been giving their notices to the tenants on a bad faith. They challenged it on that basis. So one client in particular, they bought the house. It was a very good deal. They bought it because they're all renovators. We put as is. We're not going to inspect this place because we know what to fix when we want to come in there. We don't need it. Cheap price, they bought it. And then after they, on possession date, they came in, they got introduced to the tenants, and the tenants said, oh, you're the new landlords. Oh, here's a list of all the things that the previous landlord was supposed to do, but they didn't do. And then the new purchasers in turn, oh, okay. But here's our 2 months notice to vacate because we plan to use the property. And then 2 months notice became 8 months of repeated going to the residential tenancy board because every single part of that notice was challenged. Okay, the tenants, this is a real case, and the tenants say that, oh, the real reason is because they want to avoid fixing all those things that the previous landlord didn't fix. And we gave them that list on the day of possession, and they gave us this notice of eviction. Look, it proves it. So, that was very tough. Anyways, so this is the situation here. Well, before I go to this one, this is another case where it was a tenant who had disputed the notice of eviction given to them by the landlord. So I want to skip this one because it didn't happen very often in terms of tenants hiring me to help them dispute their landlord. In that situation, the landlord gave them that notice and said, hey, I have my son in the US who's going to come live in this property. So, okay, they've got this as a close family member. But what I did was challenged everything about the intention of this landlord to actually have this son come in while he's in the US. Oh, well, okay, does he work there? Does he have a house there? Does he notice to find his boss? Does he have a visa? Did you notice that there is a ban? This was before the complete ban. It was starting to happen, but it didn't completely close the borders yet because I could have asked that question. Even though you plan to, he can't come because there's restrictions at the border or whatever. But I asked all these questions about the intentions and how to question the intention of the son and the landlord. That because they didn't make any plans for moving in, that therefore that wasn't the real intention. So this is very important, okay? You have a good cross-examination about intentions and you can get a lot of stuff out that contradicts the purpose. But that's on behalf of a tenant. It's not as common. I don't have that much as often as I do with landlords. More so as actual landlords. And this is the case where I just talked about. The previous landlord had tried many, many times to evict the tenants, but failed, and there's a track record of these tenancy board hearings. And that's an unfortunate thing. If you looked under case law to see whether the current property has been a subject of many residential tenancy applications by the tenants, you can't find the names, you can't stick in an address. What you have is codes and you have initials, but you have the issues. Unfortunately. So you can't tell. This property has the tenants taken the previous landlords to the tenancy board 15 times. You can't find that for privacy reasons. But once my clients took over, bam, oh my God. Sorry my language, but it was like, I couldn't believe the stuff that was happening. The tenants had challenged my clients. They gave the massive 1 inch thick of decisions from 10 years of litigation. The previous landlord tried to get them out with a bat. It's like, oh my goodness. No wonder that any new landlords coming in, they have so much, I don't know, suspicion and I don't know. They've got that experienced over 10 years of litigation that any new landlord coming in is just like the previous landlord. So they couldn't take the fact that my clients really wanted to buy the place for their families to move in. No, that couldn't be the reason. You saw that big list of problems. That's the reason why. You're just like the other landlord. Oh, it was awful. But anyways, one of the things that we were able to do is to give good evidence about their previous intentions before you buy. So before you buy, you have to do all these kinds of things to indicate what your intention for the property is. We also do the residential tenancy, the residential house purchase. So I had all this evidence before about my client's intentions before they even bought the house. The Form A transfer indicates where is what is the resident's intention. The property transfer tax form asks that question. The mortgage broker, who we got evidence, they had to apply for the mortgage, and they look at this property not as an investment property where income would be used towards assessment of their income and how much they're able to borrow. No, it's, well, we want to buy this house and we're going to assess it so we don't take into account your potential rental income. Oh, man, that was amazing, excellent evidence. And we even had the broker sign in and phone into the court to give that evidence. And then the previous, my clients who were buying this place, they had mutual agreements to end their own tenancy. So they were renting, and then they got the money to buy, and they've got evidence from the previous landlords, their current at that time, to say that, hey, we signed these agreements for them to leave at the time that they would have had normally gotten the house, which is 2 months after they bought the property. Excellent evidence. What you need to do is plan for that and get those evidence, because why? If you were acting on behalf of a landlord, if you were a landlord yourselves and you were challenged on the bad faith evictions because of that, you can be faced with a big penalty. Bad faith penalties are enacted in the act, in the regulations. 12 months rent as compensation. It's a lot. $2,000 a month rent. You kick them out and you got the wrong reason. Boom, you've got 12 months rent. Payment 24,000. It's not, if you don't get really cheap rent nowadays, even 1 bedroom, 2 bedroom, 2,500, 3,000 a month. 12 months rent as compensation, and normally it's not prorated. You don't get a half or two, or you're not that bad. No, you get 12 months as compensation. You do something wrong, you're found to be doing something as a landlord or on behalf of a landlord for bad faith, you get hit with a penalty pretty bad. 12 months rent. So, if you are challenged with that, be prepared and be aware of that. Landlords should be prepared to show that the reason for the rental unit that was given on the eviction notice is the only reason. But there's sometimes can be extenuating circumstances. An arbitrator can do that. And up until around June, July, I had a hearing. I couldn't find anywhere any case law. I typed in COVID under all the cases and see COVID tenancy agreement to see all the cases that dealt with COVID situation. There was none that allowed the landlord, for example, to not move in. Like if the purpose is for the landlord to move in within, say, for example, the time frame is a reasonable time after completion. So within a 6-month period of time, they better have been living in the unit, or their close family member living in the unit, if that was a stated purpose and reason given for the eviction notice. I was able to successfully argue that COVID was a reason. So in that situation, these are two particular examples, but I want to talk about one that I did where my client had his daughter live in the property and closer to the property because it's closer to the university. But then COVID happened, and she said, oh, well, my daughter moved back to the home because instead of being alone close to the university, and then it was online anyways, that it's better to be closer to home. And of course, the tenant says, hey, you're not living in the property. You told me that this with the use. I want 12 months worth of rent as compensation because you didn't do what you're supposed to say that you said you were going to do. You said you're going to live in there. You didn't. We have penalty. So boom. And then the only case, the first case that ruled on that was an extenuating circumstance. Being with your family as a complete family bubble, so that you can not be at risk all the time going out shopping, and you can do one person in the household to protect yourself. And that was accepted by the arbitrator as a reason for the landlord not to have been moving in. So I want to move in because I'm conscious of the time. I want to move in a little bit about the, let me move on to, because, nothing beats good, credible evidence, and timing of those evidence is very important. I just want to give you the scenario where one of the tenants had challenged my client by having videotape evidence of the home during the daytime and nighttime, and stuck a camera through the door, asked neighbors to keep a track of the empty home next door as evidence of the landlord's bad faith. That's what you're going to have to deal with sometimes, acting on behalf of a landlord to counteract those types of things. That person, the tenant, even rummaged through the garbage and said, "Hey, look, there's empty. I checked the garbage 3-5 times a week. There's nothing there. She's not living there." And pictures of the empty garbage can at nighttime. Oh, it's awful. Anyways, I want to move on because we don't have a whole lot of time, but commercial rents and issues dealing with that has also been very, very tough. I have a lot of landlord clients who are at that early on were waiting for the shoe to drop. They said, the tenants, they have money. I don't want to swallow my loss until I can see that the tenants really, really can't afford. And I would try to convince them that, look, nobody planned this. They're losing businesses. Don't try to tap on whatever savings they have. Try to recoup your loss. Keep the good faith in terms of having a tenant. Apply for for the Canada Emergency Commercial Rent Relief, and swallow the 25% loss. You get 50%. The forgivable loan for the government. Let the tenants live another day and continue on. But it was a very tough sell. It was hard. On behalf of that. But the government has other reasons, other ways to protect the commercial tenant. But one thing I want to do is touch on basis of the grounds upon which commercial landlord, commercial premise landlord can, and what they can do when payment rents are not paid. You can distrain for rent in arrears. So you look at the assets held by the tenant as a way of selling in order to pay off whatever is owed. You can go into the premise and terminate the lease and force basically taking over the business, and also not do anything and sue for rent in arrears. The typical methods upon which a landlord can deal with a tenant, commercial tenant that's not paying rent. But the BC government and the Canadian government can together has found ways in which you can assist and relieve avoid those types of situations so long as people participate. But the Canada, May 29th, the BC government issued a ministerial order which complemented the CECRA program, the CECRA program, which gave a forgivable loan to commercial landlords where the tenants have reduced income or have been shut down because of the orders. So the BC government issued this ministerial order to protect tenants from being evicted. The landlords who did not apply cannot therefore force their tenants to leave if they did not apply for this loan. So that was an extra measure that was used to prevent commercial landlords from just going after the tenants. In order for them to do that, they have to apply and get the assistance from the CECRA, apply for it, and give the benefit of the reduced amount that the tenants have to pay. Basically, it ends up with the landlord swallowing 25% of the rent as a loss instead of pursuing the entirety of it against the tenant. The CECRA provides eligible landlords with forgivable loans to cover 50% of the gross rent payable to eligible small business tenants, but as so long as the landlord agrees. So this is the landlord-driven one. If the landlord refuses to apply, what can the tenant do? So, the tenant is stuck, but they know that they cannot be evicted because the landlord didn't apply when they should have, and they could have been qualified. So that's an extra protection measure. However, the CECRA is over now. Those who had clients or commercial clients who had the benefit of the applying for and getting the CECRA, it's been replaced now. So the ministerial order that I mentioned, if anybody can, if you get this email to you, you can click on it. You'll see the whole order. What it says is that order applies until CECRA program is over, and it is now over. Starting now, there's another program, but there's no ministerial order that says that if you reapply for the new program, that this eviction notice then still continues to apply. It doesn't. it's over. So now commercial landlords now can start with eviction notices or procedures if starting now the tenants don't pay. Yeah. And the thing about the new, I just put this up here because um, um, uh, the preventions about what prevents what sorry the regulations that prevent the landlords from doing something in the event of these things happening. So the landlords can't re-enter, they can't terminate the lease, they can't take the property of the commercial tenant and sell it. They can't start renting out the premise to someone else. They're not allowed to do this unless they had applied. So these are all the different things that the landlord could not do, but starting now they could. If starting now that the rents are not paid, and this is very important because I was so alarmed by the increasing numbers that are coming in now, and he says, are we here in a second wave now? Is this all going to happen again? Are we going to go through this whole thing where everybody's shutting down again? Anyways, we don't have a ministerial order. It's not in effect. No, this is replaced now by the CERS. So it's no more protection until whether there is and will not be a new ministerial order or not. And who knows, like maybe after the provincial election, maybe or maybe not, I don't know. Anyways, what is the CERS? It's important to know. It's a tenant-driven one now. Before it was up to the landlords to decide to apply or not. This is not landlord-driven, it's the tenant. So there's a drastic change in terms of who can apply and who can control the process. The CERS is the Canada Emergency Rent Subsidy Program. It's a 25% subsidy for organizations shut down by mandatory public health orders, but it's on top of another 65% of the fixed expenses of tenants that can be paid for by the government as long as they qualify, and those expenses qualify. Paid directly to the tenants, so it's not like the landlord apply and gets a loan, and it's paid directly to the tenants. The end date for this program is this December, so it's still in operate. It started now until December. So other programs that may be available, so that if you have clients that needs help and you want to help them out and figure out where to go, and the CEBA, Canada Emergency Business Account, interest-free $40,000 loan, which 25% can be forgiven, and it started in April 2020. It still exists. Expenses include rent or mortgages. So if you do have a business, and this applies also if you own land and you're running a business, you have fixed expenses. Sometimes what happens if you mortgages is a part of a fixed expense that you can't avoid, or else you lose your assets as well. In October this year, it increased to give it another additional 20,000 on top of the 40,000, and it's administered by financial institutions. So it's not like a landlord applies to the government, and before the CECRA was administered by Canada Housing Mortgage Corporation, these are done by financial institutions, and you can apply up until December 31st. So these are things that exist. Now, in the absence of all of these, what do you have? Well, there are other laws which still apply and didn't change, Commercial Tenancy Act. And then there are rent deferral agreements. And a lot of people talked about this, but then they are all over the place. I have various clients of mine where we negotiated, well, okay, we don't have to pay and we're not going to evict you, but you starting next year, you start paying back overdue rent in chunks. And a lot of my clients, in the absence of at that time where they were not applying for the CECRA, they were entering into these agreements where we drafted up and then try to negotiate things that are good for both the tenant and the landlord so that they can get through this difficult time. There are a lot of things dealing with rent deferral agreements, but it's all negotiated. Commercial rent versus residential in BC is so different. That it's basically all contractual when it comes to commercial, except for these new regulations that are into force to help deal with commercial tenants and landlords during a pandemic. Just a few more things. One more thing to talk about is the law called the Law and Equity Act. So you may have a long-term lease if you don't want to, as a tenant, be evicted from because you didn't pay. There's other laws which protect the tenant. They look at these kinds of things as ways to prevent a tenant from losing their lease. It's completely discretionary. There's no entitlement to it, but there are some things to consider. Whether the sum forfeited is out of proportion to the loss suffered. So a tenant puts in $100,000 of renovations in February, doesn't pay rent in March. Can he lose all of that just because he can't pay the rent? Maybe the rent was maybe he didn't qualify for the CECRB because they dropped only like 30%, but they still couldn't pay the rent. Is it unconscionable in the equitable sense of relief? Is the conduct and gravity of the breaches so bad that they can lose everything that they put in? And these are different factors, completely unrelated to money, not just money. So something else to consider if you have a commercial tenant who can't afford the rent and has invested much in blood, sweat, and tears into the business and could lose it all. Okay. So anyways, that's my presentation today. This is my information over here. Currently the president, one of the members of AREAA as their legal counsel, but I have a practice where I do a wide range of law, deals with real estate. And thank you very much. Thank you.
Thank you very much, Ivan. Just to tell everybody that we understand that we're running over because we had our national presidents speak, for us. Now we do have a couple Q&A for those who would like to stay behind to listen to this Q&A. By all means, do so. Ivan, are you okay with the time? Because we have a couple Q&A for you.
Oh yeah, sure. Go ahead. If you can read, and someone can read the chats and choose a question, and I'll be happy to answer within whatever I can do within the time you allow.
Well, you know what? There's no time allowed. If people want to leave, the time is 6 o'clock. So
Okay.
they can leave anytime now. For those who are interested in the Q and then your A can stay. So Jordan, why don't you just give the how many questions do we have?
We had 2 questions in the chat box.
Okay, so why don't you just fire it over to Ivan?
Sure. So the first question was from Ron Wall. How to collect from a tenant who has moved or vacated without notice and is still owing rent?
Well, that's a very interesting question. I've had that situation a few times. One of the most important pieces of information is when at the start of a tenancy, on behalf of all my landlord, both commercial and residential, I conduct a credit check. It's not that much. You just have to have the form for the tenant, commercial or the residential to sign, and you include invariably information such as your bank, your credit card, your driver's license, your SIN, these things that allow you to do a credit search. That gives you a sense of something beforehand. Second thing besides this is the information for commercial tenants. They usually get a net worth statement to assess the risk level, not just the credit on a monthly payment, but what if you had to enforce terms of a lease, how much assets does the commercial tenant have? Then you can see, do they have a house? Do they have a car? Do they have a business? Is it a company? Of course, with commercial, you can also get personal guarantors involved. But the information you collect at the beginning of a tenancy is crucial because it allows you to set you up to find out things after. A SIN number and a birth date, so you have a driver's license. Those are the 2 most important pieces of information. If you wanted to, hire an agency, and we have skip tracers that we hire that does these locations. You to be surprised. I've had to find people using those 2 pieces of information, and not only do I find where they are, I find how much they have in their bank account at a certain time period, so we can apply to freeze the account and apply for an order to garnish it and have funds given to me. One time, actually last year, it wasn't good, but I managed to, on behalf of one of these clients, to actually do that. And I found out that I had the money in account. I applied for the order. Of course, you can apply ex parte, meaning you don't have to give notice. You know it's there. He owes you the money. Went in and applied, got it. The clients, the other side applied to review it. It was December 23rd. So imagine me going to court, and then the judge says, and then the person who I collected the money from, Your Honor, it's Christmas. I don't have any money to pay my, I have kids. I have presents to give, and we can't. And the judge looked at me. You can't do this. I'm putting the money back. I said, what? Anyways, timing is everything. Don't do it near Christmas if you do apply. But you get that information, you find their bank accounts, you find, you have a check in which they've given it to you, you cash the check, you know which branch they go to because you've got the check that was where you cash it, you see where it got deposited. And anyways, you know where the bank is. So anyways, more information and to do that at the very beginning. Okay.
Okay, next one.
The next question was, as an individual landlord who doesn't engage a property manager, where do they get a credit check?
Well, the online services, one of the ones that are very good, you have to be a verified landlord first, but it's called Tenant Verification Service. There's a Canadian one and the US one. So apply for an account. You have to prove that you are a landowner. For myself, I'm a property manager for landlord clients. I'm a lawyer too. That you have to have this kind of like you need to be permitted to be able to do that. And then afterwards, then you have to have a credit authorization signed by the tenant authorizing you to do that. And so when you click on the actual service and you're actually purchasing, you have to confirm that, that you have that authorization in hand. It's about $20-$30 for a personal one and about $60-$70 for a commercial one. For a commercial one, of course, if you give you a company, you don't want to do just the search on the company and the business. You want to do the shareholders and the directors as well. Okay, so a commercial one is more than one sometimes. You have two partners, you do them both. A company with 3 shareholders, do all the shareholders and the company. Of course, with tenant, you have more than one, husband and wife, 2 people, do both. Do it on everybody who's going to be obligated to pay on the home. So if you look on tenant verification services, look for the Canadian one, and that's a good place to start.
Okay, next one.
We have a question from Safar. I think he put his hand up, so maybe if you want, do you want to ask?
Yes.
Oh, sorry.
I think
Sorry,
he's
I
muted.
muted you by accident.
He's still muted, I think. Oh, there we go.
Okay. There you go. Can you guys hear me now?
Yeah,
Yeah.
we're good. Yeah.
Okay. Well, nice to meet you both. I'm first learning about this, but good to know, Ivan, that you have the law service and you do real estate as well, so you know how it works with tenants and commercial as well. It's good to learn all of that. My question was, there's a tenant that decided to leave. I wrote it in. They only gave 10-day notice. They're leaving, which is great. To me, to be honest, I'm happy. And but the thing is that my partner was saying there's some damage there, and the damage deposit is another thing. But are we obligated to get a full 30-day rent? Because they paid this month. There's only 10 days left. This is real. It actually just happened 2 days ago, and it happens that we're having this course online at the same time, but ironically, anyways. But I doubt they will give me any more money. But I told my partner the best we can hope for is keep the damage deposit, and they don't fight and just walk away. But I think we should do the walkthrough, and if there's damage, make an estimate, and also ask for the extra 20 days prorated rent money because they didn't give the 30 days. Does that make sense?
Kind of in terms of from a landlord's point of view, it's not you actually did have that motive. You didn't want them out, but before you applied to kick them out, they already left. But they left. No,
I had no intention of kicking them out. As a matter of fact, I was doing a lot of repairs and cleaning because they were complaining about garbage outside was smelly, and so I went in and like cleaned up the whole driveway with pressure washer.
right.
And all of that.
Right.
hoping they stayed. And then suddenly out of the blue, they send me an email, not even written, that they're leaving in 10 days. So I said, life happens, that's fine. But I am obligated, I told them in the email, of 30 days rent or 30 days notice.
Yeah.
Since you're leaving in 10 days, you have to pay me the extra 20 days prorated amount.
Yeah. So two parts of that. The damage deposit is only for damage and not for unpaid rent. So you can't use the damage deposit as if it was like unpaid rent in lieu of unpaid rent. You want to touch that damage deposit as a way of paying for rent that's not paid. You have to apply to the residential tenancy board to allow you to do that. So you want compensation, you can get a compensation order from the residential tenancy board. You don't only just go there for orders to remove tenants, but you can get there and get monetary orders. And then you can treat those monetary orders as if they were like small claims court. You can have it registered and enforced as if it was a court order. They owe you money, you apply to the residential tenancy board, but you do what you can to serve them, because they say, what have you done to notify them that you're applying? If they emailed you, and there's no other way to contact them, and they're in correspondence, you email back with this notice of application to the tenancy board to apply for monetary order for compensation for damages for not fulfilling the terms of their contract. And then you go to the hearing, and if they show up, and then, you know, quite often and quite often in my experience is that when they are when they do that, when they go to court, part of the evidentiary package is, well, the landlord didn't fix the light bulb. Well, the landlord didn't.
This is exactly what I'm expecting, and
Yeah.
I predict as well.
Yeah, and if they do that, well, then you have to go and prove everything. They have to prove, first of all, that you prove that they owe you, and they have to prove that you owe them. And it's like, you know, balance and probabilities type thing. Yeah, pictures.
Is it even worth it for, like, you know, 20 days extra of rent? It's like $700 some, like for my time and small claims, the cost for the court fees. I don't know how much they are.
Court isn't that much, you know. I think it's only $100 something. I don't really look into how much the application costs are. But if you hire a lawyer, of course, you know, that's like 2 hours of work. 1 hour there is already gone. But you can look at the rules and stuff, and look at cases and whether it's doable. A lot of people just going around. Arbitrators don't necessarily look to see if there's a lawyer. They prefer that the lawyers are not there, I think. we tend to be really wordy and throw cases all the time.
Just to wrap up my issue real quick. The response I got, by the way, she did respond to my email and said that it totally didn't respond to the prorated amount that I asked for, but agreed to do the walkthrough this month, October 30th. They said they'll have the place ready for a walkthrough inspection by 1 o'clock. So that's for the $850 damage deposits, unrelated to the short notice. Yeah, but I suspect there will be damage that I can easily estimate over $850, because there was bubbling on the laminate floor, and you know, there's a few holes in the wall. They had a lot of pictures and stuff.
I don't like that. A few quote on few. Yeah. Hopefully it's not too much. Hopefully it's not too much of a damage there for you, and hopefully they're reasonable and pay you back.
If they walk away and say, okay, keep the damage and we're not going to pay you the prorated, I'll be happy to, you know, if they just leave and go.
Yeah, and one of the things you might want to do then is to get a mutual agreement to end the tenancy. You know, they already left, you can still have that and put down on the terms, and that even though they're leaving early, you're not going to charge them, but they're not going to ask you to compensate them for anything either. Okay.
Definitely, I'm going to document that email with the forgiveness of the $700 some.
And there's an actual form you downloaded from the website. It's called the Mutual Agreement to End Tenancy. Even though basically you already ended it, it doesn't hurt to document it and put all your agreements down there and sign it. And both of you sign it. Prevents them from suing you later. Okay.
Okay, they're month to month now. They're way over a year. Like, they were good tenants. They always paid on time.
Yeah, it's still the
dirty
same thing.
Though, but paid on time.
You can still say it's a mutual agreement to end the month-to-month tenancy before the month is over. Okay.
So fill up that form for sure. Thank you.
Thank you.
So any more? If not, then we can wrap it up, because we are already 15 minutes behind.
Yeah.
20 minutes behind.
just one more plug. AREAA. If you those out there who are not members, check us out and
Yeah,
can give
join
more-
us, and we have more of these educational and practical events, that the board does not run, because it's not just academic things, like it's practical informations that we need it for our business. So thank you very much. And just a final reminder, please put down your V number if you need to have your PD, if you would like to have your PDP. But once again, thank you so much, and until next time.
Thank you.
Thank you, Ivan.
Thank you.
Thank you, Tina. Thank you, everyone, for joining.
Thank you.
Bye.
You.
Bye-bye.
Thank you.
Okay, we can stay behind. Oh, good. Okay. So make sure everybody put their V number.
They just put that in the chat line, Tina. Is that what they do?
I don't want to just end it and then they cannot put their chat,
Okay, yeah. Well, that's a good thing.
right? If I end everything, so I don't know who forgotten, right?
Awesome.
So we still have 14 people checking out.
Well, we're chatting here. I had other Zoom presentations with other real estate brokerages where, as they sign in, they needed the number in order to sign in. So it's like you can't sign in unless you have a number, something like that. I don't know if that, like, before they even allowed into the chat, they've got their number. So I don't know.
It's a different system that we exploring.
Okay.
Yeah. So maybe after this, when we go to our group chat, you can share with us who, and then maybe you can find out for us.
Oh, okay. Yeah, sure. Yeah. Okay.
Yeah, it's better because you just finished doing that, right? So try find out what systems they use.
Yeah. Yeah, sure. Okay.
So Jordan can stop recording now.